Imagine for a second that a hacker breaches your smart home system,
Scary.
right, from like 1,000 miles away. They bypass your digital locks, they take control of your house's thermostat, and they intentionally cause it to overheat and basically burn your house to the ground.
Wow.
Did they just commit burglary and arson without ever stepping a single foot on your property?
Welcome back to the deep dive.
Glad to be here.
Usually when we talk about a legal concept, there's this expectation of like absolute precision.
Right, yeah.
You read the statute, you apply the rule, and boom, there it is. But when we look at how the law protects the physical security of our homes and our property from intrusion and destruction, suddenly we're looking at a legal landscape that has morphed radically over the centuries.
It really has.
Today, your mission as a listener is to understand the evolution of three ancient property crimes that have changed completely over time. We're talking burglary, criminal trespass, and arson.
Hmm.
So how exactly does the law define crossing the line from just a simple unwanted guest to an actual felon? Yeah, and to truly grasp these concepts, you cannot just, memorize a list of definitions. It doesn't work that way.
No, definitely not.
We really have to dissect the court's reasoning element by element. So today, we're going to trace a very specific analytical path to show you exactly how this works in practice.
Perfect.
We're going to examine the erosion of the breaking requirement in burglary, then look at the intent and privilege elements of modern criminal trespass. And finally,
The big one, arson.
exactly, the shift from protecting a habitation to protecting property in modern arson laws.
I love that. I actually like to think of the common law rules as this ancient, massive fortress wall.
Okay, I like that analogy.
And over the centuries, modern courts have slowly dismantled that wall, just brick by brick, to fit today's world. So let's start with that first brick, which is burglary.
Let's do it.
What actually constitutes a burglary? And I mean, does someone literally have to break something, like shattering a window or kicking down a door, to be guilty?
That's a huge misconception, actually. Under the general rule for common law burglary, there are 5 distinct elements.
Okay, what are they?
It's defined as, first, a breaking; second, an entering; third, of the dwelling house of another; fourth, in the nighttime; and fifth, with the intent to commit a felony.
Right, so a lot of very specific conditions there.
Very specific. The original purpose here was to protect a sleeping family in their sanctuary, right? But regarding that breaking element, it did not require actual violence or destruction.
Wait, really? So no smashed windows required?
No, not at all.
Yeah.
The law wasn't asking occupants to turn their homes into literal impenetrable fortresses. It just meant creating an opening that the occupant had previously secured.
Oh, I see.
Yeah, so simply turning the knob and opening a closed but totally unlocked door was sufficient to constitute a breaking.
Okay, well, that makes sense. You breached the security the owner set up, however minimal that security was.
Exactly.
But, the sources mentioned this fascinating thing called the chimney exception.
Ah, yes, the chimney exception.
Right, because a chimney is basically just a hole in your roof. It's as close as it can possibly be to still function, right? So sliding down an open chimney somehow counts as a breaking. I really want to see how this ancient logic applies today. So let's analyze Goldman v. State. First, what are the legally dispositive facts?
Right, so in Goldman, the defendant entered a Goodwill collection box.
Okay.
But he didn't smash the lock or anything. Instead, he basically climbed up into the box through the chute that was specifically intended for depositing clothing donations.
Okay, wow. And what was the core legal issue there?
The issue is, does climbing into a donation chute, which is permanently open by design, satisfy the breaking element of burglary?
Interesting. So what rule of law did the court apply? Please state the full black letter rule and break it down into its testable elements.
Sure. The court applied the rule for constructive breaking regarding implied invitations.
Constructive breaking, okay.
Right. And the rule has 3 testable elements. First, an opening exists. Second, the opening is necessary for the structure to function as intended. And third, the opening cannot reasonably be viewed as an implied invitation for a person's entry.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the existence of an opening?
So the sub-issue here is whether a breach actually existed. The sub-rule requires an access point into the structure.
Right, which seems pretty obvious here.
Exactly. Applied here, the donation chute was a clear physical opening into the box. Therefore, the conclusion is that element 1 is met.
Understood. Now, what about the second element, the necessity of the opening for intended function?
Right, so the sub-issue is the structural purpose of the opening.
Why is it there, basically?
Exactly. The sub-rule states that an opening designed for goods, not people, operates much like a chimney.
Oh, there's the connection.
Yeah. Applied to these facts, the Goodwill box inherently needed the chute to receive donations. I mean, it simply couldn't function as a collection point without it. So the conclusion is that element 2 is met.
And the third element, the lack of implied invitation. I mean, why doesn't an open hole just mean, come on in?
Well, the sub-issue is occupant negligence versus functional design. The sub-rule states that functional openings do not constitute an owner's failure to secure the structure.
Okay, I follow.
Applied here, leaving the chute open wasn't an invitation for humans to enter. Like, if you leave your front door wide open, you are failing to secure your home.
Right, that's an implied invitation.
Exactly. But a functional chute is different. So the conclusion is that element 3 is met.
And after analyzing all the elements, what was the court's final conclusion?
Synthesizing the elemental analysis, the court's ultimate holding was that climbing through the donation chute was completely analogous to the common law chimney exception.
Wow, so the old law holds up.
It does. Because the box was as secure as it could be while still functioning, climbing through that functional gap constituted a valid breaking.
That is absolutely fascinating. So the fortress wall doesn't have to be shattered. Exploiting a functional gap is enough.
Precisely.
Let's move to the second element of burglary, which is entering. What if the burglar's body never actually crosses the threshold, but they use a tool, say, reaching a coat hanger through a gate to snag a purse?
Ah, okay. The general rule for entry by instrument is quite specific. It has 3 elements.
Okay, lay them out for me.
First, an instrument crosses the threshold. Second, it breaches the occupant's possessory interest. And third, it is used to accomplish the intended felony.
Okay, got it.
Crucially, it cannot merely be used to effect the break-in itself. For example, using a crowbar just to pop a lock doesn't count as an entry.
Oh, because it's just breaking the lock, not taking the stuff?
Exactly. The tool has to be doing the actual stealing or committing of the felony.
Okay, let's put that rule to the test with People v. Davis. First, what are the legally dispositive facts?
The defendant in this case walked up to a check cashing facility, and he placed a forged check into the commercial slide, or the chute at the teller window.
Right, those little metal sliding drawers. And what was the core legal issue?
Does inserting a forged check into a commercial chute constitute using an instrument to effect an entry for the purposes of burglary?
Okay, so what rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the rule for instrument entry. This rule has 2 main elements we need to focus on. First, the physical intrusion of an instrument. And second, the intrusion violates the occupant's possessory interest in the building.
Thank you. Now for the court's elemental analysis, let's walk through this step by step. How did the court apply the first element, physical intrusion of an instrument?
The sub-issue is whether the check actually crossed the threshold of the building.
Which I assume it did.
Yes. The sub-rule states that any item pushed past the building's exterior boundary suffices. Apply here, the forged check passed fully into the facility's interior through the chute. The conclusion is that element 1 is met.
Wait, I have to push back on that.
Okay, go ahead.
Before we go to the second element, if the check crossed the line and his intent was to commit a felony, forgery and theft, why wouldn't that just be a burglary right there? The tool crossed the threshold to commit the crime.
It's a great question, but it fails because of the second element, violating the occupant's possessory interest. The law cares deeply about the nature of the intrusion.
The nature of it, okay.
Right. The sub-issue is whether the physical security of the space was threatened. The sub-rule states the instrument must threaten the physical security of the habitation or the property within it, going well beyond a mere transaction.
I see where this is going.
Applied here, placing a check in a chute is essentially no different than handing it to a teller or mailing it. It doesn't breach the physical security of the space in the way that, say, reaching a hook inside to extract stolen goods would.
Right, because the building is designed to accept paper there.
Exactly. The possessory interest of the building itself isn't violated by a piece of paper meant for communication or commerce. Therefore, the conclusion is that element 2 is not met.
And after analyzing all the elements, what was the court's final conclusion?
Because the check did not violate the possessory interest of the building, inserting it was not an entry, therefore, the burglary charge completely failed.
That is wild. Okay, Time to test the absolute limits of this rule with something unforgettable.
I'm ready.
Imagine a thief who coats a live, trained ferret in thick, gross restaurant grease.
Oh, no.
They send this greasy ferret down the narrow ventilation shaft of a jewelry store to fetch diamond rings. But the ferret gets stuck, and only its little greasy paw dangles through the ceiling grate into the store. Did a burglary occur?
Well, that is quite the visceral visual. But legally, the analysis is airtight.
Really? Tell me.
A trained animal acts as an instrument, or constructive entry, via a tool under the actor's control. Under the elements we just discussed, the ferret's paw, crossing the plane of the ceiling grate, even momentarily, satisfies the physical entry.
Wow, just the paw.
Just the paw. Furthermore, it breaches the possessory interest, because the ferret is not conducting a normal transaction like a check, right?
Definitely not.
It is actively threatening the security of the property within to accomplish the intended felony, which is fetching the diamonds. Therefore, yes, legally speaking, the greasy ferret's paw constitutes a completed entry for burglary.
A greasy paw equals a felony. I love it. So burglary requires an intent to commit a felony once inside. But what if the person crosses the threshold without a criminal intent? Say, they just refuse to leave a place.
Like a bad house guest.
Yeah. Where does the law draw the line between a stubborn guest and a criminal?
Well, at common law, simply being somewhere you weren't supposed to be was only punished as a crime if the trespass breached the peace.
Meaning what, exactly?
Meaning it caused a public disturbance or actual violence. Otherwise, it was just a civil matter, lawsuit.
Okay.
But modern statutes created the crime of criminal trespass to address unauthorized intrusions more broadly. The general rule for criminal trespass contains 3 elements. First, the defendant enters or remains unlawfully, meaning without privilege.
Got it.
Second, on specified premises. And third, doing so knowing that they are not licensed or privileged to be there.
Okay, knowing is the key word there.
That third element is crucial. It requires a subjective, knowing mental state. In legal terms, this is the mens rea, or the guilty mind. The law doesn't want to criminalize someone who just made an honest, innocent mistake.
Okay, let's test that mental state element with the case. In re Jason Allenby first, what are the legally dispositive facts?
So, a youth was given a no trespassing warning by police at a public housing complex. Sometime later, he returned to that exact complex, but he did so at the explicit invitation of his cousin.
And the cousin lived there?
Yes, the cousin was a current longtime resident there.
Okay. And what was the core legal issue?
Can a defendant be convicted of criminal trespass if they return to a property they were previously banned from, but they do so with an objectively reasonable belief that a resident's invitation gave them the right to be there?
Great question. What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the rule for the mental state of criminal trespass. The rule has 2 elements. First, the entry or remaining must be objectively unlawful or unprivileged.
Okay.
And second, the defendant must knowingly enter or remain without license or privilege, meaning they have a subjective awareness of the unwarranted intrusion.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, objective unlawfulness?
So the sub-issue is whether the housing authority's ban trumped the tenant's invite.
Right. Police versus cousin.
Exactly. The sub-rule states that landlords generally cannot bar a tenant's licensee or guest from common areas. Applied here, the cousin had a legal right to invite guests, making the youth's presence arguably objectively lawful. However, the prior police warning really complicated his actual legal status.
Understood. Now, what about the second element, the knowing lack of privilege? I mean, why does his personal belief matter so much here?
Well, the sub-issue is the defendant's specific mental state. The sub-rule states that an honest and reasonable mistake regarding one's legal right to enter completely negates the knowing requirement for the crime.
Ah, so if you don't know, you're not guilty.
Right. The law requires you to know you were trespassing. Applied here, the youth genuinely believed he was allowed to return as long as he was visiting a resident.
Which makes sense.
Yeah, given that tenants generally have the right to invite people over, the court found this to be an objectively reasonable belief under the circumstances. So the conclusion is that element 2 is not met.
And after analyzing all the elements, what was the court's final conclusion?
Synthesizing the analysis, because criminal trespass requires the actor to subjectively know their intrusion is unwarranted, the youth's reasonable belief that his cousin's invitation made his entry lawful barred a criminal conviction.
That's really interesting. So the mind of the trespasser matters just as much as their feet, basically.
Exactly.
You can't accidentally commit criminal trespass if you genuinely and reasonably think you're allowed to be there.
Not under modern statutes, no.
Well, we've covered unlawfully occupying a space. What if the goal isn't to occupy or steal, but to completely destroy the space?
Moving on to the heavy stuff.
Yeah, let's talk about arson. Does it only apply to burning down someone else's house?
Under the strict common law, yes. The general rule for arson was defined precisely as first, the malicious, second, burning, third, of the dwelling house, fourth, of another.
Wait, of another, so you couldn't burn your own house?
You couldn't even commit common law arson on your own house because the law was designed to protect the habitation of others, specifically to prevent sleeping people from burning to death.
Wow.
But modern statutes completely changed this. Today, arson includes damage by explosions, it covers commercial buildings, cars, and crucially, it covers your own property if your intent is to defraud an insurer.
Let me stop you on that second element, though. Burning. What exactly counts as a burning? Like if I accidentally knock over a candle and it scorches the wallpaper in my apartment, turning it black with smoke, is that arson?
Let's do an elemental analysis of the common law burning element to understand why that distinction matters so much. At common law, there was a strict difference between charring and scorching. Charring means there is actual combustion of the material the building itself is made of, like the wood of the walls or the floor must literally begin to transform through fire.
Okay, so the structure has to actually catch fire.
Exactly. That satisfies the element. Scorching, like blistering of paint or black smoke damage from a candle, does not. The structure itself had to be compromised.
So under the old rules, if I just melted the paint, I was totally off the hook for arson.
Exactly, you're off the hook. However, we have to note that modern statutes have broadened this significantly because that old rule left way too many dangerous acts unpunished.
I can imagine.
Many jurisdictions now say simply damaging a building by fire or explosion is enough, regardless of whether the wood actually chars. And even further, under the Model Penal Code, arson is treated as an inchoate offense.
Let's unpack inchoate. What does that mean in plain English?
Inchoate means incomplete or just begun. In this context, it means the crime is the act of starting the fire with the requisite bad intent.
So it doesn't even have to burn?
Nope. Just starting a fire with the purpose of destroying a building is enough to be charged, even if the fire is put out before the building actually burns at all.
That is a massive shift from the common law, from having to literally char the wooden bones of someone else's house to simply lighting a match with bad intentions near your own insured business.
A huge shift, yes.
You promised us an analytical path today, and we have definitely walked it.
We really have. And to fulfill that mandate, I want to synthesize all these rules into an actionable, step-by-step diagnostic checklist for you, the listener.
Oh, perfect.
Think of this as a mental framework you can use to unpack any of these scenarios whenever you see them in the news or if you ever need to spot these issues yourself.
Okay, lay it on us.
Step 1. Identify the physical intrusion. Did any part of the body or a felony-enabling instrument cross the threshold? This goes straight to the entry element of burglary.
Right, like the ferret paw.
Exactly, the greasy paw. Step 2. Analyze the threshold itself. Was a possessory interest breached, or was there an implied invitation? This tests the breaking element in burglary and the unlawful entry in trespass.
Okay, making sure the space was actually violated.
Right. Step 3. Check the clock and the map. Was it night? Was it a dwelling? These are critical for common law grading and elevating the severity of burglary and arson.
Got it. Nighttime makes it worse.
Always. And finally, step 4. Interrogate the mental state at the exact moment of entry or action. Was there an intent to commit a felony for burglary? Did they know they weren't allowed for trespass? Did they act maliciously or with an intent to defraud for arson?
So, mens rea.
Exactly. If you follow these 4 steps, you can unpack any fact pattern.
That checklist is invaluable. It shows exactly how those ancient fortress walls were dismantled, examined, and just rebuilt into the modern codes we use today. Which actually leaves you with one modern, mind-bending question building on everything we just discussed.
Okay, let's hear it.
In the beginning, I asked about a hacker burning down your house by remotely turning up the thermostat.
Right. The smart home scenario.
Yeah. So, if they never physically crossed the threshold, is there an entry? If the digital lock was bypassed, is it a breaking?
That's a tough one.
The ancient common law never saw the internet coming. But as we've learned today, the law isn't just a list of rigid rules. It's a living logic that is always evolving to protect our possessory interests. Think about that the next time you lock your doors or, connect your fridge to the Wi-Fi. Thanks for joining us on this deep dive.